Good morning to you and welcome to our jurisprudence class. So last week we discussed command theory or the imperative theory of law, uh, championed by Jeremy Bentham and John Austin. We did note that essentially command theory of law, they try to explicate law in terms of a sovereign giving commands or giving orders backed by sanction or backed by threat of punishment or force. And again, we saw how in the case of uh, Bentham, he did not necessarily give us a detailed picture of the nature of the sovereign, but then John Austin came and told us that the Austin is an uncommanded. In other words, the Austin, I mean, the sovereign is himself or herself above the command that he gives. And he sought to draw distinction between various usages of law, which he thinks some are improper. So he talked about the fact that law, strictly so-called, is the proper province of legal philosophy or jurisprudential inquiry into the phenomenon of law. But then we also saw the shortcomings of his approach, particularly so the explanatory power of his approach is more appropriate, I should say, for criminal law, right? For criminal law, it makes sense. But if you go beyond criminal law, his explanatory power begins to crumble. Now, this morning, we want to look at Kelsen and hopefully Hart. Now, Kelsen, you might have encountered him already when you were learning constitutional law in the first year of your LLB. So there is a topic which is usually thought of as the legal effect of coup d'etat or revolutions on a pre-existing constitutional order. That when there is a coup d'etat or revolution, when it is successful, what happens to the legal order, the legal system, the laws which were in place before the coup maker succeeded? Now, there's something called the theory of continuity and discontinuity. And those who support the theory of discontinuity will often allude to Kelsenite thinking and its use of the Grue norm and so on. You remember the case of Salah versus Attorney General, the case of DPP against Michel, the case of what do you call the ex-party Matovo, and then Mazimabutu against Lagnabek. All those cases presented opportunity for the relevant courts to explore the legal effect of coup d'etat or revolution on a pre-existing constitutional order. If you are interested in refreshing your mind on this particular segment, I have done the constitutional law lectures already. If you go to the Ghana Law TV channel, I think if you try to search for effect of coup d'etat revolution on constitutional order, you get those lectures and then you can play it back. And these cases are discussed there. So who is Hans Kelsen? And is Hans Kelsen a natural lawyer or legal positivist? Or he's something else? Well, the authors of Law's Jurisprudence, Michael Freeman, would suggest to us that, and of course, a suggestion is not in vacuum, that if you look at Kelsen closely, the fact that Kelsen rejected natural law theory because in Kelsen's view, natural law confuses the law with morality. And again, Kelsen also rejects legal positivism because, in his view, legal positivism confuses the law with facts. So he's accusing natural law of confusing the law with morality, and he's also accusing legal positivism of accusing the law with facts. So where does he fit? What is his own pedigree? What is his standing? Well, he is going to introduce a new terminology, norms, and he will tell us that law consists of norms. And in his view, a norm cannot be derived from facts, but only from other norms. So that's what I want you to put at the back of your mind at the very introduction. That for him, a norm, law is made up of norms, and he says that a norm does not consist of facts necessarily. A norm is derived from other norm. And that is why he will postulate that law consists of norms. So I want us to keep that in our mind as we move on. And he will make another point which we want to highlight at the very introduction, that for him, he wanted to develop what we call the pure science of law. And he said he's not doing a theory of pure law, but it is a pure science of law. So let's develop his ideas in bits. Yeah, so Kelsen lived between 1881 and 1973. He was an Austrian-American jurist. And although for convenience of classification, we treat him as belonging to the school of positivism, despite the fact that in his own reckoning, he doesn't see himself as such because he had castigated positivism of trying to look at law in terms of facts. And he said that law is not just a matter of factual reality, it's a matter of norms. And norms derive their validity from succeeding or preceding norm, as it were. He was instrumental in the crafting of the Australian Constitution, adopted around 1920, and he became a judge at some point of his life at the Australian Supreme Court, Supreme Constitutional Court, and when he ran away or migrated to US, he took part in the drafting of the Charter of the United Nations. Now, the object of his theory is to assist in understanding of positive law in general. So here we're using positive law as in like the man-made law, okay? Not of any particular legal order. So Kelsen attempts to explain what the law is and not what the law ought to be. And his work as M.D.A. Freeman, the author of or the editor of law jurisprudence, will remind us is that his work should be accepted as a contribution to the science of law and not to legal politics. And in that respect, its sole purpose is to know its subject. So its sole purpose is to know its subject. And that is why you call it the pure theory of what? Of law. So Kelsen was determined to make a rigorous inquiry, a dispassionate, probing or interrogation based upon a strict methodology. A strict methodology devoid of all other, impurities, as he will put it, things which are not really necessary to be taken into account as we try to explicate the nature or the essence of law. So Kelsen aimed to construct a pure science, and a pure science of law with emphasis. A pure science of law devoid of all impurities, like all issues of politics about the law, did not matter. And this pure science of law is supposed to be grounded in positivist philosophy. Now, he stands tall from other positivists, especially John Austin, in the sense that his work sought to establish a system where law could be studied independently of external influences, such as political ideologies or moral beliefs. And that is why Kelsen's approach was carefully pitched to make legal analysis strictly objective, in that he emphasized that law should be understood purely on its own terms. Law should be understood purely on its own terms and not on any other terms. And of course, as you can see, Kelsen can properly be subsumed under what we call the formalism. Those who look at law as a closed system, then you can understand it on its own terms. But later on, Jürgen Habermas will also tell us in the systems theory of law. So, in Kelsen's view, this rigorous approach he's talking about requires a methodology that excludes subjective values and focuses solely on legal norms. So in that respect, you see that he's rejected morality. He's also rejected facts, as it were. And he's talking about something else, legal norms. So we can say that Kelsen's understanding of law is premised on the notion that law is a normative system. When we say a normative system, that is a system of norms that prescribe a behavior. So law is a normative system. Now, mind you, some people have told us that law is a command or orders backed by sanctions. That is a command theory. Now, Kelsen is drawing a line and say that no, in his view, law is a normative system, a system of norms that prescribe behavior. And these norms are not simply commands or expression of will of any sovereign, but are abstract prescriptions that carry a unique legal force. And that is why we have noted already that scholars see Kelsen's pure theory of law as standing out in jurisprudence for its rigorous attempt to separate legal science from other forms of normative analysis, specifically morality and ethics. So as you remember, our natural lawyers will tell us that law must be evaluated strictly and inseparably in terms of morality. But Kelsen is saying that no, we have to look at law as a matter of science, as a matter of norms. So if law is a system of norms, and for that matter, he sees law as a normative system, what is a norm? In Kelsen's work or his framework, a norm is understood as a rule that prescribes certain behaviors. He's not talking about rule, but we are just trying to explain what you mean by a norm. That a norm is some sort of like a rule which prescribes certain behaviors. And legal norms, unlike moral or social norms, derive the authority from their position within a formal legal system. And that is why we noted in the beginning that for him, a norm derives its validity from another norm. So, Kelsen will trace validity of norms to succeeding norms until it will get to what we call the ultimate norm, or what we call the grand norm, beyond which there is no any other norm. And all norms within the legal system, within the legal order, derive their validity ultimately to that ultimate or that grand norm. So Kelsen's primary interest was in understanding the structural elements that give norms their binding nature. Yes, if law is a system of norms and if norms prescribe certain behaviors, what is the source of validity of the norms? What makes the norms binding? What makes the norm valid? This was his concern. So Kelsen argued that the validity of a legal norm is not based on its moral or social value, but on its relationship to other norms within the system. So it's just like, let's use this analogy, just like like a chain, right? If you have like a chain, you have like the various links, linking one to the another. So if we take any particular link, it derives its sustenance from the preceding one. The preceding one, so for that order until you get to one very last one, which is supposed to be the ultimate or the grown. And that is why Kelsen will make the point that law consists of a hierarchy of norms. Hierarchy of norms, that is structure of norms. And this hierarchy of norms, each derive its authority from a higher norm. Like hierarchy, hierarchical arrangement of things, either in ascending or descending order. And within this hierarchy, each norm derive its authority from a higher norm. And this chain of validity ensures that each legal rule is connected to an ultimate foundational norm. And this ultimate foundational norm, Kelsen will call the GRU norm. The GRU norm. So the GRU norm is the primary norm, the ultimate norm, which gives validity to all other norms within the legal order. In that respect, Kelsen will tell us that law is a normative pyramid. A normative pyramid. And when we say normative pyramid, I hope you know what a pyramid is. Let me try if I can get a picture of a pyramid. I have the Egyptian pyramid, which I visited some years ago. Okay, I think I've managed to pull it. Now with internet, things don't get lost like that. So, so the pyramid is, look at the back. I took students to Cairo for the African Human Rights Moot Court competition, where we won. KNUST won at the time. So these are the students who went. I think they're all lawyers here, apart from the one to my right, who's the administrator. So behind us, that's what is important to me. Behind us, what is behind is what I want you to see. This is the pyramid. I hope you are seeing, somebody can raise up a sound to signal if you are seeing what I'm showing. Are you seeing what I'm showing? Okay, all right, thank you, because you are there. Yeah, so the behind us, not the human being, look at the behind, that's the pyramid. If you look at how it is. Good. Thank you, Afrifa. Look at this one. What is behind? That is the pyramid. And good. This is a better view. Look at how it is. So that way. So Kelsen is telling us that for him, law is like a pyramid of norms or normative pyramid. And if you take I wish you can see like the top, but let me see if we get another one where we see we see the apex. Good. So please look at the top here. So this is like the apex. And He would even explain, if you like, the legal order as an inverted pyramid. Inverted pyramid in the sense that it's turned upside down. So that like this apex, if you like, is at the bottom, as it were. And this is supposed to be like the ground which gives validity to all other norms within the legal system. So, in Kelsen's view, law is a normative pyramid. And now you know what the pyramid is. I've shown you one. With the ground norm at its apex. So the pointed top there, if you like, that is apex. And that is the ground norm which serve as the ultimate source of validity for all subordinate legal rules. So his work is introducing us to the hierarchical structure of law, in which every norm's validity depends on its relationship to a higher norm within a chain of norms. So maybe if you wanted to visualize the hierarchical structure, Kelsen is endeavoring to introduce us to, we have, like the ground norm, like the basic norm, which is like the ultimate foundational norm that form the basis of a legal system. And all other norms derive their validity from this norm. So the apex, which is like the ground norm, is a source of validity for all norms within the hierarchy. Then he talks about constitutional norms. And constitutional norms are to be at the level immediately below the ground norm. So the candidate's constitution provides authority for creating other norms within the legal system. And then the legislative norms, like the various laws passed by legislative bodies as authorized by the constitutional norm. Administrative norms, rules and regulations created by governmental agencies, which derive their authority from legislative norms. Judicial norms, judicial decisions and case law that interpret and apply legislative norms and filling gaps and resolving ambiguities. So therefore, Kelsen is telling us that in his hierarchical model, each norm is connected to a higher norm from which it derives its authority. So a statute derives its validity from the Constitution. Maybe if you are to even liken it to our own legal system, so if you take Article 11 of the Constitution, you take Article 1, 2, and Article 2. We have supremacy of the Constitution. We have enactment by Parliament. We have subsidiary legislation, the common law, which is like the decisional or judgment law. Now, all these, in a sense, if you are to analyze them in terms of Kelsenite thinking, some may point to the Constitution as the ground norm, but I think that is erroneous, or that one is an error in the sense that from Kelsen's own thinking, there's a ground norm beyond the Constitution. If you look at it, that is why I say that like the ground norm, the basic norm, the ultimate foundational norm, that form the basis of the legal system. And all other norms derive their authority from this group norm. And then he will set the constitutional norm immediately below the group norm. That after the group norm, what comes immediately is a constitutional norm. And that is why it is wrong for anybody to point to the Constitution as a group norm. Because in Kelsen'S thinking, the Constitution derives its authority from the group norm. And then the Constitution will be giving authority to other norms like the legislative norm. The legislative norm, that is the House of Parliament and so on, will also be giving validity to regulations made by administrative bodies, such as under the various subsidiary legislation and so on. And then judicial norms or decisional law, judges who make law, but the authority so to do is derived from the Constitution, from the legislative norm, which set up like the court, and which endows the court to jurisdiction or the power of adjudication. So let's look at this. If you remember, look at this structure, and then let's go back to oh, sorry. I wanted to show you. Good. So look at the thing again. You see? So these are the apex. And then you can turn it upside down like that. So this is inverted pyramid. So this is like the apex, the group norm here. This validity to the next norm in that order. And Kelsen was of the view that the structured hierarchy is essential to ensure that legal systems function as coherent, unified entities. So, like, I'll give you an example. Let's say that a policeman orders you to stop because you are overspeeding. Now, the policeman ordering you to stop is some sort of like a norm. He is sort of prescribing a behavior, or he has a norm who tells him that if a certain behavior or conduct is seen, he must take an action. Now you want to find out what is the source of that policeman's authority. The source of that policeman's authority is the fact that the IGP has given him the authority. What is the source of the IGP's authority? The IGP is given authority by, let's say, the Police Service Act. What is the source of authority of the Police Service Act? The Parliament made it. What is the source of authority of Parliament to make a Police Service Act so as to give another person a norm to do certain things? The constitutions gave the power. What is the source of authority of the Constitution to give Parliament power to make laws? The group norm. So that is what Kelsen is trying to tell us. So the group norm, or the basic norm, is at the very heart of Kelsen's theory, as it represents the foundation upon which a legal system is built. And Kelsen will tell us that the group norm is not a written law or explicit command, as it were. The group norm is rather presupposed. It's a presupposed norm. So you make like a presupposition that is there. And that norm, that presupposed norm, the group norm, provides the basis for the validity of all other norms within the system. So therefore, we could say, as it were, that the group norm is like a hypothetical norm, right? Hypothetical norm accepted by society as the foundation of legal validity. So if that is the way he explains it, can we see the group norm in our own country, Ghana? Yes. What do you think? Let me take two responses. What do you think is like the group norm in our country, Ghana? Based upon the way that Kelsen has explained it. I need two students, one female, one male. Raise up your hand so that I'll call you. Okay, good. So iPhone, please use your names when we're doing online class so that I'll know who is present. Okay. Okay, let's hear.
Yes, sir.
Good.
Hello,
iPhone.
sir.
Yeah. Yes.
Yes, sir. I'm Francis.
Good.
I believe the grown norm will be the belief of the people coming together to decide that they will follow a certain constitution to lead them.
Okay. 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 Thank you, Francis. Let's take I think Eric. And one lady should put up a hand because I need to hear a lady's voice. Yes. Eric, you can mute.
In the context of our Ghanaian legal system, then the ground norm will be the constitution, because per Article 11 of our constitution, and per Article 11 of our constitution give us the hierarchy of our law. Then Article 1 also establishes the fact that the constitution is the law of the country, and all other laws must be consistent with it. And any law which doesn't act or contravenes the provisions of the Constitution shall, to the extent of its inconsistency, be void. So I believe and I think the Constitution will become the highest law. And for that reason, the ground norm for which all other sorts of laws must get their validity.
Okay, Eric, thank you for your contribution. But what you have said is a reflection of what some judges in Ghana think, which I respectfully disagree with them that I think they are getting Kelsen's theory wrong. You read some of the Supreme Court, decisions, and sometimes you hear, judges referring to the Constitution as the group norm. If you are going strictly by Kelsen's theory, I think it is wrong to refer to the Constitution as the group norm, unless we don't understand Kelsen's original work. Yes, Atama. Atama, you can unmute.
Thank you, my lord. In my opinion, the grown in this case is the people who came together to bring about the constitution. The constitution derives its validity from the people. That's my opinion, my lord.
Okay, so because we are friends, and I want you to be very clever in the law, I'm giving you an assignment on this particular thing now. Let me write it for you. So assignment. Identify at least 5 cases decided by the Supreme Court or other superior courts in Ghana, in which the court used the word grown and critically assess whether it was used properly in accordance with how the proponent and Kelsen explicated it in his work, The Pure Theory Good. So I hope you can see what I put in the chat. I don't know if you can see it. I hope you're able to see it, isn't it? Okay, if you can't see it, I'm reading it for you. Assignment. So identify at least 5 cases decided by the Supreme Court or other superior courts in Ghana in which the court used the word grown and critically assess whether it was used properly in accordance with how the proponent, Hans Kelsen, explicated it in his work, The Pure Theory of Law. So deadline for submission I'll give you not next Sunday, not tomorrow. Today is 15, so plus tomorrow will be 16 plus 7. Plus 7, that should be. No, can have it like the Saturday. So let me have it by Saturday. So 15 plus 7 is 22. So it's 22nd November. And this one, there should be what we call the hard copy submission. Class rep will collect and make sure that students sign their name and index number upon submission. And when class rep will take instructions from me as to how I'll get the hard copies if I haven't come to Kumasi. Class rep, are you able to confirm if you have followed the instruction? Type in the chat so that I know. Or anybody? Are we communicating? All right, thank you. Good. So, okay, I think Jamfi's hand is up. So let's take Jamfi and then we continue. Yes, Jamfi, you can unmute.
Hello, good morning.
Morning.
My Lord, I wanted to express my view on what I think the ground norm is.
Okay. But you got my assignment.
Respectfully, yes.
All right. Yeah, so let's hear you.
I'm thinking that when we talk about ground norm in the Ghanaian perspective, we look at it from the ancestral world. Because as we have all come to believe that the world is existing, from the Christian perspective, we believe in a God that created this world. We have never seen that God before, but that is our belief, that once the world is existing, then somebody brought the world into existence. So that somebody is spirit. And once that spirit is able to bring the world into existence, the same spirit has the command, of which others can also take their validity in terms of command from that spirit. So in the Ghanaian perspective, if we are talking about the ground norm, then it might be the ancestral spirit. And out of that we emanate our spirits from, and of course, all the things that we have been able to put in place, which laws are also part.
All right. Thank you very much. Yes. Yeah, so the gronom, as we indicated, according to Kelsen, is not a written law or explicit command. Rather, it is a presupposed norm that provides the basis for the validity of all other norms within the system. And in a way, it is a hypothetical norm accepted by society as a foundation of legal validity. Some of you said that, well, in Ghana, it will be like the people. Some may even point to the fact that we had a referendum. And then the referendum is the one which leads to the adoption of the Constitution. So the validity of the Constitution is from like the referendum which the people of Ghana had. That is what some people argue, but I don't think it accurately reflects Kelsen's explanation of Grunum, although it comes close. Because the other point will also be that the referendum, there was somebody who made the referendum possible. We had a military ruler called J.J. Rawlings, who passed a law which sought to make the referendum possible. So, can we say that it is the person who made the referendum possible who is like the Grunum? And the person who made the referendum possible, what was the source of his authority? Where did he derive his authority from? We know he made a coup d'etat. He overthrew the government of Liman, the PNC, and he imposed himself on the Ghanaian people for more than 15 years or so. He was the leader. So can we say that because he was successful in imposing himself, and as whether something remain valid or not, it was with his tacit approval, so that if he didn't agree, that we don't accept it, or this is no longer the case, that will be it. can we say then that his success at the coup d'etat and his ability to have established himself so that for the time that he was in charge, everything derived validity from him, should we see his coup, the phenomenon of his coup success as the grown-up? Well, these are questions that beg for answers, and we have to keep reflecting and asking those questions. So the grown-up serve as the ultimate criterion of legal validity within a particular system. And in Kelsen's view, the authority of all legal norms depends on their connection to the grown-up. And this ultimate norm is necessary to provide a stopping point in the chain of validity. Without the grown-up, Kelsen puts up the argument that legal norms will lack a definitive source of authority, and this will lead to endless regress in search for legitimacy. Those of you who know regression analysis, to lead to endless regress in search of legitimacy. We'll be trying to find out what makes this legitimate, what makes this valid. We keep searching. We never get to any definite answer. And that is why he says that the grown norm is a presupposition, the presupposed norm. And once that presupposition is made, it gives validity to all succeeding or other norms, as it were. So, in constitutional democracy, the grown norm might be the principle that the constitution is the supreme law of the land. But again, if you are to just suppose it straightly by the original exposition by Kelsen of the grown norm, it will fall short, because if you are talking about the constitution, then Kelsen will talk about the historically first presupposed constitution, that historically there was a first constitution, and no one knows when that first constitution was. And it is that which provides validity to all subsequent constitutions and other legal norms. If that is how we are looking at constitution here, then that could be like the grown norm. But if we are just looking at the constitution, for example, in Ghana context, just because we have the 1992 constitution, and the Article 1, 2, and 2 says that is the supreme law of the land, and that we have the grown norm, that may be a bit misleading and not a proper appreciation of what Kelsen taught us. So this presupposition allows all subsequent laws, regulations, and judicial decisions to be considered legally valid as they are created, applied, and interpreted under the authority of the Constitution. So, in Kelsen's work, he tries to put emphasis on the fact that validity of a legal norm is independent of its content. That is to say that as whether a norm is valid or not is not what the norm is telling us or what the norm says or does not say. Rather, a norm's validity depends solely on its place within the hierarchical structure. So remember the pyramid that we look at. If the norm can be located to be falling within the pyramid, then it derives its validity from the preceding or the succeeding norm, as the case may be. And this view that the validity of a norm is independent of its content, of what it says or does not say, is consistent with Kelsen's own objective to establish a value-free science of law. Mind you, he calls his work the general theory of state and the pure theory of law. So the pure theory of law, pure, trying to purge any values from the legal science. And as you say, legal validity is purely a matter of formal authority, not moral content. And that is why Kelsen has told us that norms are valid when they conform to the procedures and authorities outlined by higher norms in the hierarchy. For that matter, the law prohibiting theft is not valid because it aligns with moral principles, but because it adheres to the constitutionally defined legislative procedure that grants this authority. In other words, if we have a Criminal Offences Act, right, which criminalizes, let's say, that the stealing, it's not because stealing is morally reprehensible or obnoxious. Of course, we know it's morally reprehensible or obnoxious, but it is not that which makes that criminal statute valid. The validity of it has to do with whether it derives its force, its validity from a valid norm. So you will say that it was made by Parliament according to the procedure for making laws. So the procedure for making laws, Parliament, they all derive the authority from another valid norm. And if the Criminal Offences Act has come out from them, then that is valid. And it's not valid because it, for example, criminalizes stealing. And that is why Kelsen is telling us that validity of a norm is not dependent upon its content. It's not the content. So once they conform to the procedures and authority outlined by the higher norms in the hierarchy, they are valid, as we have noted. So Kelsen's theory requires that we view law as a self-contained system where validity is determined solely by the legal structure, not by extra-legal considerations. In other words, within Kelsen's thinking as whether we have a valid law or not is a question we have to answer by looking within the law, not outside it. Within the law, the relationship between the various norms will let us know whether a particular law is valid or not. Now, Kelsen acknowledges that law is distinct from other normative systems. We have other normative systems which also play their own function, but law as a norm, in his view, stands on a different pedestal because the normative system established by law is typically associated with what? With coercion. And that is why Kelsen will say that law is a coercive order. A coercive order where norms are backed by potential sanctions or consequences. You are supposed to do this, or you're not supposed to do that. And the person who is prescribing that derives authority from another valid norm. And now if you do or if you don't do that, there are consequences. So that is the coercive order. And this feature differentiates legal norms from moral or social norms, which generally lack no such coercive force. For example, hospitality is a noble thing, isn't it? Showing love and kindness, compassion to strangers so that they feel at home. It's good. That is a social or moral norm, as it were. But strictly speaking, if you sack a stranger from your house or your community, you've not committed any legal wrong because you've not violated any norm, as it were. But Kelsen is quick to remind us that despite the fact that he's talking about coercive order, the presence of coercion per se or ipso facto does not define law. It's not because we have coercion. That is why we say that we have like a law. No. And he's trying to make a point of departure from the teachings of the command and imperative theories like Jeremy Bentham, John Austin, and others. On the other hand, it is Kelsen's view that coercion is a characteristic that many, but not all legal systems employ to enforce compliance. The element of force, be it sanctions or consequences, in his view, can be seen to be running through a lot of legal systems as one of the important mechanisms of ensuring compliance or adherence to prescribed standards. So therefore, Kelsen will remind us that what makes a system of norms a legal system is not coercion itself, but the existence of a structured hierarchy validated by the GRU norm. So if you have like a hierarchy, hierarchical arrangement of the rules or the legal norms, and if you can trace the validity of all of them to an ultimate norm, to the GRU norm, it is that which makes the legal system valid, but not just because when certain orders are not carried out, there will be sanctions. No, that is not it. And in that respect, despite Kelsen's own reservation, commentators see Kelsen as being firmly rooted in legal positivism. That is to say that he focused on law as it is, positively. After all, what positivist says that the province of jurisprudence or jurisprudential inquiry should be law as it is and not law as it ought to be. And for that matter, for Kelsen, studying law scientifically means analyzing the actual content and structure of legal norms without resorting to subjective moral judgments. And of course, that is a clear departure from natural law. And positive law then will be the law created by human authority within a specific system And its validity is determined by its relationship to the group norm. So as you will notice, the group norm is a thread which runs through Kelsen'S thinking in terms of validity of the legal order or the legal system. And we are emboldened in our description of Kelsen as being a legal positivist in the sense that he makes the point that legal norms can be valid regardless of their ethical content. And of course, all legal positivists espouse that particular tenet or that teaching. And his focus on positive law reinforces the idea that the law's authority stems from its formal properties and adherence to procedural rules rather than any inherent moral qualities. So let's keep that in mind. Now, we don't need to be convinced that Kelsen rejected natural law theory from what we have been discussing so far. And we know natural law take the view that law must be grounded in moral or ethical principles. But Kelsen disagreed, and he rather argued that natural law introduces subjective values into legal science, and it makes it impossible or it makes it tenuous to study law objectively. If you want to study law objectively without any preconceptions, predilections, biases, then natural law cannot help us. So Kelsen makes the contention that natural law theories undermines legal stability by allowing moral arguments to challenge the legitimacy of legal norms. Now he strikes a contrast or counterfactual point to the effect that legal validity depends solely on the norm's position within the legal hierarchy, not about its moral worth or its content. Moral evaluations, in his view, may well influence the contents of laws, but do not determine their legal validity. Yes, you can let moral matters color the law. That is fine. But when we are trying to determine the status, the pedigree of the norm, the law within the legal system, it should not be dependent upon its moral content. And this separation of law and morality enables a clearer and more scientific analysis of law, consistent with his project, Pure Theory of what? Of Law. Now, we have noticed by now that no theory is sacrosanct, and every theory of law has got its own flaws in one way or the other. And so it is with Kelsen'S Pure Theory of Law. Critics attack Kelsen on the grounds that he placed too much emphasis on formal validity, and that ignores practical realities of how laws operate within society. That his obsession is too much focus on the formal arrangement of the law. Is out of step with how law actually works on the ground in society. And critics argue that laws are often evaluated based on their content and not merely their position within a hierarchy. Another critique, also related to what we just talked about, is the fact that he has detached his law or his approach from social realities, and is so much steeped in abstraction of law as a normative hierarchy. And that again disconnects his thinking from everyday application of law, where judges, lawmakers, and citizens consider social factors, policy implications, and ethical concerns. That is what happens. And in fact, in the courts, there is the doctrine of substantial justice, where sometimes the Supreme Court and some other superior courts will go to the extent of trying to water down the formal prescriptions of the law and try to advance what we call substantial justice, try to say that do not allow form to supersede what in substance the true position of things should be. And of course, if you take even equity, the relation between equity and common law is like that. Equity looks at the substance and not the form. There's another problem with the Brunom, and the criticism is to the effect that the Brunom is too vague and overly theoretical. So some critics opine that the Brunom is an artificial construct that fails to account for the dynamic and evolving nature of legal system. If we look at legal system, it's really not static, it's quite dynamic. And you begin to wonder whether his concept of Brunom is always valid and can provide overarching explanation for the legal system, regardless of the various phases of time and development that it travels through. By also excluding morality from his analysis, Kelsen has been criticized for potentially legitimizing unjust law. And that is significant, especially if you put it in the context of the Nazi regime. What happened in Germany during the leading to the Second World War? Adolf Hitler and his wicked legal agenda, including the extermination of the Jews and so on. If you take Kelsen's teaching, so serious, there's a risk that we may tolerate unjust law simply because we are able to see it as deriving its legitimacy from a valid norm. And particularly if you adhere to Kelsen's teaching that it is not the content of the law which determines its validity, but it is its relationship with other succeeding or preceding legal norms. So that is problematic and is dangerous as it can allow immoral laws to persist so long as they conform to hierarchical structure. So just look at the situation. Let's go back into history, right? In the Bible, the Holy Bible, the New Testament. When there was a king called Herod, when the baby Jesus was born, we are told the wise men went there, and when they narrated their revelations and encounter, the star, this new king, and so on, the Bible tells us that Herod was alarmed because he saw Jesus as a threat, and so he needed to destroy him, and so that he doesn't become a king. And we know the law he made. He made a law that, I think I stand to be correct, but if I remember my Bible correctly, that all those who are below the age of 2 should be killed. So I'm just using this to illustrate the criticism against Kelsen. You say that the decree that they should kill all children below 2 years, in Kelsenite thinking, is valid because the decree was made by the king, and then the king has his authority from the Grunom, so that is valid. However, it is unjust, it is immoral. How can you just say that we should go and kill all children below 2 years? So that is the kind of thing that we are facing as far as fidelity to Kelsenite Grunom is concerned. It can legitimize unjust law, immoral law. Well, notwithstanding the criticism, we will try and see how Kelsen's ideas have been applied in modern legal system, particularly when it comes to constitutional law and international law. In various constitutional systems around the world, the idea of Grunom has been instrumental in establishing the supremacy of constitutional law. And that is why the Constitution is seen as being in a class of its own. Those of you who do the law of interpretation of statutes and deeds later on in the law school, you notice that we talk about interpretation of statutes and non-statutory documents. And then when we are talking about statutes, we talk about statutes on one hand, and we talk about the interpretation of national constitution. When it comes to constitution, it's treated separately because it is its own class, as it were. So we could say that Kelsen's hierarchical model is visible in legal system where laws derive the authority from foundational documents like constitution. Yes, so even if it is not perfectly reflected, in a sense, we get the logic of its thinking being reflected in our legal system. You take our constitution, for example, Article 1, Clause 2, Article 2, and then Article 11. Again, in international law, you've done public international law. Kelsen's theory has influenced development of supranational legal systems. In what ways? Where treaties and conventions form a hierarchy of norms binding on member states. So if we take the Vienna Convention on the Law of Treaties, which you have learned, we notice that you can have multilateral treaty, bilateral treaty. Now, when these treaties are entered into, they create binding obligations. But we also acknowledge that international law does not have a single Grunom. I think it will be interesting if we can force the United Nations Charter as a Grunom. It will not be. That notwithstanding, the concept of ultimate legal basis continue to shape the understanding of legal authority in international relations in one way or the other. So if you have questions, we will take them before we introduce Hart.